And a very good morning to you. It's John Fradgley from the Bell Legal Group, back with you for another program of The Law and You this Tuesday morning. As it is every week, your opportunity to get free legal advice between now and 9:30. All we'd like you to do is get on that phone as soon as you can. 55208888 is the number. That number again, 55208888. Or if you're not able to get on the phone and you'd like us to answer a question, you can always email us at talkback@4CRB.com. So that's talkback@4CRB.com. And thank you to all the people who called in last week and made for an interesting program. Many and varied calls, and of course that's always a great thing for the program, because not only can we answer their questions, but we can also help out, hopefully, with other people listening to the program who might have similar queries. Probably expecting it to be a little bit quieter today because we've got Radiothon going on, but nonetheless, we are still here to answer your questions. So who knows, you could be our very first caller this morning on 55208888. While we're waiting for some calls to come through, last week I started talking about the Advance Health Directive. And where that differs from voluntary euthanasia. And of course, there's been a great debate going on in Australia about voluntary euthanasia for some time. The law in Australia clearly provides that it is illegal. And so, therefore, people need to consider if they have particularly strong views about how they wish to be treated in the event that they have a terminal illness or otherwise are hospitalised and with injuries that they're unlikely to recover from. You need to consider how you want directions given to the people who may be treating you. And of course, the only time to do that is going to be while you are still competent and able to do it, because once you end up in hospital, if you're unconscious or you've lost legal capacity, you no longer have the capacity to be able to issue any of those directions. And so the Advance Health Directive is a very, very comprehensive document available in Queensland and I think in most other states, where you can lay out quite clearly the circumstances in which you wish to have treatment or you don't wish to have treatment. And so, for example, you would be able to say that if you suffer a stroke and you're regarded as brain dead, that you do not wish your life to be artificially prolonged through being on life support. And you could issue a directive to say that you wish to be given pain relief to ensure that you're not in pain, and also obviously that fluids are kept up so that you're reasonably comfortable. But they're the sorts of things that you can in fact address in an Advance Health Directive, and I think it is increasingly a document that many people will consider using as the population ages and we see more and more people entering nursing homes with dementia. It is a real issue because so many people you speak to say that if I ended up in a state where I could no longer look after myself, I have to be fed because I can't feed myself. I have no awareness of what is going on around me. I'm not able to go to the toilet anymore. I can't shower myself. All these sort of situations. So many people I speak to say that they would not wish to have their life maintained in such a situation. And obviously the only way that that can be addressed at present legally is through the Advance Health Directive. 55208888 is the number if you have a question or a query for the Law and You this morning. That number again, 55208888. We'll be back after this word from our sponsor.
Here's an offer to make you smile. Pay nothing out of pocket for a dental checkup, x-rays and clean if you have Health Fund Extras cover. That's right, a no-gap exam, x-rays and clean at participating Maven Dental practices. Now that's an offer to make you smile. Book your appointment today. Visit mavendental.com.au to find your nearest practice for more information and T's and C's. mavendental.com.au. Maven Dental, making smiles.
A sponsor.
This May, the 10 Tenors return with their brand new show, Love is in the Air. Fall in love 10 times over as these romantic tenors serenade you with the world's greatest modern and classic love songs. Don't miss the 10 Tenors Love is in the Air tour. The Arts Centre Hotter, Friday, May 24. Tickets on sale now at the10tenors.com.
A sponsor.
And you're in tune with 4CRB 89.3 FM. This is The Law and You this morning. 55208888 is our number. That number again, 55208888. Probably the quietest morning I think I've ever known since this program began. So if you're out there with a question or a query this morning, please give us a call straight away. 55208888 is that number. The other thing that I was talking to Barry Coleman earlier today about that I wanted to address this morning related to estate planning and why estate planning is far more than just doing a will. But we have a caller online, so we'll go to them. As we say, a very good morning to Mohammed. Mohammed, how are you this morning?
Not bad at all, just driving. Can you hear me clearly?
I can hear you quite clearly. Thanks. How can I help you today?
Yes. Look, John, I'm a medical practitioner, and I get put in this situation where I am to help people giving advice on the Advanced Health Directive and helping them fill out the form. So I've got two little questions for you.
Sure.
One is a person needs to have reasonable cognition and mental capacity to actually answer those questions appropriately.
That's exactly right.
Because some of them, the example that you gave, they become a little bit complex. As you know, in medical circles still, there's this debate about artificial, say with brain death and so on. So it's a bit complex for medical practitioners.
Sorry, Mohammed, you're just breaking up a little bit at the moment. Could you just repeat what you said?
Yes. So what I was saying was it's a little bit difficult to try and explain to the patient with limited cognition about minor aspects of that decision. That's one question. The other one is, if a person has done an Advanced Health Directive and 2 years down the line they change their mind but haven't written it down but have whispered it to their daughter or their son or somebody, which is in contrast to what they documented, where do we stand there?
Well, of course, the Advanced Health Directive is, as I understand it, is not legally binding on a medical practitioner. So even if you've got an Advanced Health Directive in place, it is still, at the end of the day, the doctor's decision as to whether they will act in accordance with the Advanced Health Directive or not. And before too many people out there get alarmed by that, I must make it very clear that I have certainly never seen any instance where a doctor has failed to act in accordance with an Advanced Health Directive, except perhaps in the circumstances that you may be outlining there, Mohammed, where the person has spoken to someone in the family and said, look, I no longer want this particular treatment, and so it may be that a change is made. Going back to your very first point about their capacity, and this is a very, very important issue because in order to make an enduring power of attorney, the level of capacity, of mental and legal capacity required is far higher than that required for a will. And when you go through the Advanced Health Directive form, you're quite right, it is a very, very complex form. I mean, it has a huge number of questions, and quite honestly, I don't envy you as a medical practitioner having to complete that form because there are so many questions and the person has to initial next to those questions as well. So you then, of course, have to sign off to say that you believe they had the capacity to understand what they were doing, and then it then has to be signed by them in front of a witness who has to say that they believe the person understood the nature and effect of the document. So it is that's why I was saying it's so important for people not to leave these documents to the last minute, because you need to have a very clear understanding of what's going on.
Yes, thank you. Can you still hear me?
Yes, I can.
Yes, I mean, that makes it easier for me to understand, and of course, we share the concern that it is complex and can be quite sensitive, and I entirely agree with you, the sooner the better.
Yes.
Because we are aging, cognitive impairment does kick in, and I see it frequently. In fact, it is becoming complex. It's a privilege to be able to do it, but it's not short of its complexities, and one wishes it was simpler.
Yes.
And in fact, I've noticed that fragile people with fragile cognition become quite anxious during those questions and
yes.
think this is going to happen to them, and you have to keep convincing them that this may not happen to you. But in case it does, then what would like? And they lose the plot a little bit there.
Yes.
And but look, no, thank you for that. And as I said, I'm a geriatrician. I often get involved in these matters.
Well, thank you very much for calling in, Mohammed, because you've certainly given a different perspective on it, and one that not only I appreciate, but I'm sure our listeners out there will appreciate as well.
Pleasure. Thanks a lot.
Okay then, have a good day. Cheers now. And the time on 4CRB is just coming up to 17 minutes past 9 as we say a very good morning to Ron. G'day, Ron. How are you today?
Oh, good morning. Yes, I'm very well.
How can we help?
John, parents lending money to their children, not big amounts, maybe say 30,000, and you draw up a loan agreement because they are going to give you a bit of interest. Can each of the two people you're lending to be the witness to these documents for each other?
I would not recommend that. I think that you should have independent witnesses. So if you're lending, for example, to your daughter and son-in-law, I don't think it's a good idea for your son-in-law to witness your daughter's signature and your daughter to witness your son-in-law's signature. And bear in mind, you don't need qualified witnesses, so any witness will do. So, you could just have a next-door neighbour or something like that witness it, as long as they're over 18 years of age.
Okay, and do I need to have a loan agreement actually witnessed?
Look, it's not critical that it be witnessed, but it's probably not a bad idea to have it witnessed, just so that if there's any argument later on that that the person didn't sign it or that there was a misunderstanding or anything like that, I think having a witness, an independent witness, just adds a little bit more to the strength of the argument.
Okay, thank you very much.
Okay, then, all the very best, Ron.
Cheers.
Cheers now. And it's 18 and a half minutes past 9 right here on 4CRB as we say a very good morning to Sharon. G'day, Sharon. How are you today?
I'm good, thank you. How are you?
I'm well indeed. How can I help you today?
I wanted to speak about converting homes to multiple occupancy. I have a neighbour that converted his home to occupying buildings with fully like apartments, without getting council approval.
Right.
I have been to the Scenic Rim Council. We're on very small blocks up here, 100 square metre blocks, and we have on-site sewage treatment. So we don't have main water or sewage connected, so all our waste goes onto our blocks of land.
Right.
So when you have multiple people in those homes, the effect on the environment and on neighbours is quite substantial.
Yes.
Anyway, Scenic Rim Council has now said he's not allowed to do that, thankfully, but they've found another way around by saying that they just got borders in the home now. Is there any sort of protection for neighbours in this situation. I've been told now by Scenic Rim Council, they can't do anything about that.
Yes, well, unfortunately, I think that what they're telling you may be correct. Certainly if the zoning of the property is not, the first thing is for, multiple dwellings. If the zoning of the property is not correct for that type of thing, then obviously that can be stopped. So it's all about council zoning. The other thing that might be worthwhile is going back and having a look at the original development approval for where you are to see whether is it in a do you have a body corporate, or is it just a separate blocks and
just separate blocks?
Oh, okay, so you have you just have basically a wastewater treatment like an enviro cycle.
Yes, for each block.
Yeah.
Well, actually,
So the only thing I could suggest you do is just see whether the council have any bylaws that cover the maximum number of people that can occupy a particular property. I mean, obviously, if there's a home that's got 3 bedrooms and they've got 2 people in each bedroom, so they've got a total of 6 people there. Well, that's no different to a husband and wife and 4 children living in a property. So that's a little bit difficult to stop. But we might just have to. That's probably about all I can help you with, Sharon. But I will have to move on because unfortunately we've got a number of calls sitting there. But go back and speak to the council just in relation to what their requirements are in terms of maximum occupancy. All right then.
Okay.
All the best.
Right.
Cheers now. Bye. And we say a very good morning to Karen. G'day, Karen. How are you today?
Hello?
Yes, Karen, how can I help?
Yeah. Look, I've got a friend who lives in a retirement home, and he's made, his own will. He's only got a couple of $1,000s in the bank. And he made the will and had it signed by 2 witnesses. Is that legal enough?
Unfortunately, without seeing it, I wouldn't be able to tell you whether it's a valid will or not. So the requirements for a valid will are that the document revokes any previous wills, that it appoints an executor, and that it clearly disposes of the estate. So if the will says, this is the last will of me, Joe Brown, I revoke all former wills, I appoint Bill Smith as my executor, and I leave the whole of my estate to Nancy Smith, then that should be okay. It must be signed. At the foot of the will, it has to have a date on it. It needs to be signed and have 2 independent witnesses who are not beneficiaries. So if all of those steps have been taken, hopefully the will is valid.
Okay.
All right?
All right.
Okay, but I must stress, though, that without seeing it, I can't comment definitively. All the best. Cheers now.
Thank you. Bye.
And we say a very good morning to Gordon. G'day, Gordon. How are you today? Gordon, are you there?
Oh, yes, John.
Yeah, how can we help you today?
Thank you. That ended quickly. I didn't hear.
Yeah, that's quite okay. No trouble.
Thank you. John, my comment is for public interest as well. I was shocked a week or 2 ago to discover that a good friend has had a petition to reveal her will, to present her will as her daughter-in-law, who's not yet divorced, going through a divorce with this lady's son, after nearly 3 decades of marriage, has decided to leave the marriage, and she's made an application to have her will revealed. How does that?
Well, I think it's disgraceful, but unfortunately, in family court proceedings, you do find that spouses endeavouring to see what assets their former spouse is going to have after the marriage and property settlement is over, do want to know what sort of inheritance they're likely to receive. And often it may not be regarded as an asset for the purposes of the property settlement, but it may be looked upon as a possible financial resource. I think it's terribly unfair that it's done. I think that, there should be a basis upon which it can be revealed, but only to the judge in the family court proceedings, so that they can consider it in making their decision. But I think it's certainly very unfair that the document should be made available to, for example, to the lady's daughter-in-law who's presently divorcing her son.
Yes, well, it sounds to me to be a very premeditative action after so long in privacy, in the confidence of those people, knowing what they stand to lose, and then they still leave anyway. They're the ones breaking the vows.
Yes. Well, the other stupidity of it is that your friend could make a new will anyway, which completely excluded her son if she wanted to. So, there's no guarantee that they're going to receive that.
No, and on the other hand, they could do a reciprocal petition against that other person's relatives.
Yes,
and
exactly.
But, John, is this just a Queensland law? Or
No, it's under the Family Law Act, so it's federal.
Oh, okay.
All right then.
So it is a fact they have to deal with.
It is something they will have to deal with.
Thank you, John.
Okay then, all the very best. And the time just coming up to, just past 26 minutes past 9. We'll say a very good morning to Owen. G'day, Owen. How are you today?
Hello?
Yes, Owen. How can we help?
Yeah, g'day, John. Yeah, it's about, thanks for bringing up the subject of the Advanced Health Directive.
No trouble.
And the voluntary euthanasia thing. I hear that if you have which I have with an office you're familiar with, an Advanced Health Directive.
Yes.
And I hear that if you get rushed off to hospital, you better have a copy of it with you.
Yes.
Because they might start resuscitating you.
In circumstances where you don't want it.
When we don't want it. And also, if you move from that hospital to another hospital, and it's probably the medical people won't probably have time to carry it on for you.
Yes.
So,
although these days, a lot of those documents, Owen, are now entered into the computer system. So, with health records, I know, for example, that if you get rushed off to Gold Coast University Hospital, your GP can look up the records of what happened to you while you're there, and I believe that things like advanced health directives are part of that as well. So it's not quite as bad as it used to be.
Right, yeah, okay, yeah. Because it's a bit of a worry, because you won't be thinking of taking things
No, that's
with you.
for sure. I mean, if you're in the middle of having a heart attack, the last thing you're going to think, oh, gee, I must go and grab that advanced health directive before they stick me in the ambulance.
That's right.
Yeah, I think you might have other things on your mind.
I think so, yeah.
But hopefully somehow, though, that will get to the right place. So, even if perhaps you keep a copy of it in a bag that might be the bag you'd take to hospital, so it's there.
Yeah. I suppose so, yes, that's right. Okay.
All right.
Thank you.
Okay, Owen, all the very best. And 28 minutes past 9, we say a very good morning to Brian. G'day, Brian. How are you? Brian, are you there?
Yes, John.
Yes, how are you today?
Good. John, I recently remarried. A few months back, I had a new will drawn up to include at the time, my partner, since married. And in the will, I've nominated her as a beneficiary. And if something was to happen to me, she could stay in the house, etc. Now that I've remarried, do I have to have a new will drawn up to have her name changed to my name?
Did you, when you made that will, is there a clause in it that specifically says I'm making this will in contemplation of my marriage to so-and-so?
I'd have to check that. But I do recall at the time I raised that with the solicitor and said, no, there's no need to change the name. The name that I've got on that will, which is the one prior to her now married name, he said that would suffice. No,
that certainly would be okay, but just double-check the will to make sure that there is a clause in it which specifically says that you've made the will in contemplation of your marriage to Mary Smith or whoever it is.
Okay.
But the change of name is certainly not necessary.
Okay, thanks, John.
All right, because if the will wasn't made in contemplation of marriage, the will you made is now revoked. That's why that provision in there is extremely important.
All right, I'll check that.
All the very best. And it's 29.5 minutes past 9. We've still got a couple of callers online. We've got Brian and Mary. So if you can just wait online, if you don't mind. I'm sorry that we're going to have to do that, but we do have the local news coming up shortly. This is John Fradgley from the Bell Legal Group. It's been great to be with you this morning for another program of The Law and You, and thank you for that avalanche of calls that came in after such a slow start. If you could do one thing for me today, which I would really appreciate, and that is that if you have over the years obtained advice from The Law and You, and you appreciate this program and the service that it does provide to our community, I'd be very, very grateful if you could call in and become a supporter of 4CRB. So if you could get onto that telephone line, 55208888, and pledge your support to 4CRB. $60 a year is all it takes, and we can ensure that programs such as The Law and You continue for many, many years into the future. So until next week, it's goodbye and God bless.